This is part 4 of Selecting and Influencing Your Jury, produced by the Professional Education Group, featuring Dr. Susan Jones.
One of the things you may have observed, and I'm not a lawyer, I'm a psychologist, but I've been dealing with the legal field for 21 years. There was one thing I observed early on and I was terribly confused by. And that was, during opening statement, I heard the attorney get up and say, "Ladies and gentlemen, thank you for being here. Thank you for your time." And, of course, there was this long, drawn-out whatever instead of just sort of getting to the point. But there was this thank you, whatever. Thank you for putting up with everything. Thank you for this. Thank you for that. And, by the way, as the judge has told you, this is the opening statement. This is my chance to tell you a little bit about our case. And as the judge has pointed out, what I'm going to be telling you is not evidence. I'm just going to be giving you kind of a roadmap. And I thought, wow, that's kind of weird. But is that in the Code of Civil Procedure? Are you required to say that? I was a little confused. But then I was in trial early on, and we had a case. Again, I was on the defense, civil defense, and opposing counsel was going to do his opening statement, and I knew opposing counsel by reputation, who had a reputation as a superb advocate, and indeed was. I mean, through the whole process of discovery or whatever, it was clear that this guy was sharp, he was on his game, he was good, and I had heard that he was marvelous in front of a jury. And so, opening day of opening statement comes, and I'm sitting, on the defense, listening to the plaintiff's opening statement, and indeed, this guy was superb. The judge says, "Counsel, you may proceed with your opening statement." And I swear, counsel leaped from his chair. It was just like one motion. It was just a split second, and he was up in front of the jury. And I have a copy of the transcript from what he said. And he got in front of the jury, and he said to them, you could hear a pin drop in the whole place. He said, "Ladies and gentlemen, this case is about how Ms. Holmes, my client, was fraudulently deceived into believing that there had been a partnership, and how she's been wronged, and how those two people combined together to cheat her out of her due." There's the way to open a case, right? There's the punchline. This is what it's about. And it was just a perfect zing. The very next line in the transcript from his opening statement was, "Now, what I've just told you isn't evidence. Let me make that very clear." I thought, what the heck? Why did you do that? You've seen it happen before? People get up and say, and you don't have to do it, right? There's no reason that you have to do it. The judge has already done that. The judge has already said what you're about to say is not evidence. What I have always wondered is, why don't we use our opportunity in the first few minutes with a bit more strength and a bit more affirmatively? And that is, instead of saying what I'm about to tell you isn't evidence, instead say to the jury, "I will show you the evidence we have uncovered." What? That's a different statement, but that's what the trial is about, right? You will be showing the jury the evidence you have uncovered. Most jurors, remember, have no legal training, right? Haven't been in a courtroom but for divorce court. That's the most frequent occasion people have been in court, by the way, divorce court. Don't know about a process called discovery. They don't know that you know what's coming up. So in opening statement, unless we tell them we already know, they think, well, what you're telling me is what you hope will come out, or you're hoping things will turn out that way. Instead, if we take a moment or two early on in the opening to say to them, "I will show you the evidence we have uncovered." And what I mean, ladies and gentlemen, is that prior to this trial today, there has been a process supervised by the judge called discovery. Discovery is the opportunity of counsel on both sides to examine the witnesses who will be here today under oath. It's called a deposition. The transcript is written. The record has been made of the testimony. Each side has exchanged documents. We have subpoenaed their documents. They have subpoenaed our documents. We have seen the documents in this case. So I will show you the evidence we have uncovered during discovery to persuade you that indeed my clients have been wronged or treated unfairly or whatever. And I thought, well, in fact, counsel did that. Just that he inserted this whole thing about not evidence. I don't know, maybe he had one of those senior moments, I don't know, and he just sort of lost it for a second. Because he came back shortly thereafter and did just that. He said to the jurors, ladies and gentlemen, what I am telling you in this opening statement are facts that I expect you will hear from the witness stand. The reason I can tell you what I believe the evidence will show and what facts will be coming from these witnesses is because since last August, the latter part of last year, and up to the present day, the parties, the defense, counsel for his client as well, we've all collected information given to us under penalty of perjury, where people have to swear that it's the truth. And it's in the form of what we call a deposition. And he went on for like maybe 30 seconds more to go on and explain it. And then he went on to say the evidence. What a difference. So, for opening statement, if we're not required to tell people what I say is not evidence, don't, because as we have learned before, this is your second chance to testify. So don't undermine the testimony you're about to give in your opening statement by telling jurors that what I have to say to you is not evidence. In fact, they will, as we said, confuse the source of your statements with the testimony that they hear.